I'm going to try to do this video in about a half hour because I do have a live show tonight. I have one co-host that is not going to show tonight, but hopefully the other guy will. If not, then I'll be by myself. I'm going to, of course, try to invite Vaporized Nomads, Adam Miller, as well as Tristan Thompson from the Vape and Legion Network. If they show, great. If not, then I will just do the show for 1 hour. But anyway, I wanted to share this with you guys. So this is July 17, 2017, and it says Wrigley sues a vape company over juicy fruit double mint cigarette flavors. E-cigarette manufacturers have long produced liquid nicotine in a variety of flavors like strawberry or cotton candy as a way to entice users with something that doesn't simply taste like nicotine or smoke. But Chicago vape company's attempt to appeal to customers' palates has garnered the ire of candy maker Wrigley, which accused the e-liquid maker of infringing on its juicy fruit and double mint brands. Chicago-based Wrigley, which is owned by candy maker Mars, filed a lawsuit last week accusing Chi-Town Vapors of trademark infringement for producing and selling double mint and juicy fruit flavored liquids for e-liquids. And it goes on for a while longer. And then I'm going to share these other things with you here. Now, I had done this on Chi-Town, I don't know, about a month ago or so. They actually had received from the Center for Tobacco Products, Food Drug Administration, a FDA warning letter on June 21st, 2017, for having sold this particular product, a Foggy Dew Strawberry Fields e-liquid, was misbranded to someone younger than 18 years of age. The FDA's investigation of Chi-Town Vapors.com, and I presume they have changed, they complied with the FDA. And then if you go to Chi-Town website, they are really a real big kind of company here. They say on their website that they have a certificate of registration. Says this certifies that Chi-Town Labs Incorporated is registered with the U.S. Food and Drug Administration. But if you read lower down on this certificate, it says the U.S. Food and Drug Administration does not issue a certificate of registration, nor does the U.S. Food and Drug Administration recognize a certificate of registration. Register Corporation is not affiliated with the U.S. Food and Drug Administration. So if you go to Wiki, it says Register Corp USA was founded in 2003 to assist businesses to comply with U.S. Food and Drug Administration regulations. And then if you go to the Register Corp page, it says domestic tobacco manufacturers are required to register their establishments with FDA, as well as list their products and report their ingredients to FDA. Now, if you go back to their company's website and you click on their home page, this is what comes up. It says manufactured in a FDA registered facility, which is complete, utter garbage. And not only that, they have the registered word. They don't even know how to spell. Look at the spelling of registered. It's like registered. So let's go to the lawsuit. And this is in the United States District Court for the Northern District of Illinois' Eastern Division. Is W.M. Wrigley Jr. Company, plaintiff versus Chi-Town Vapors, and Robert Wilson, defendants in the jury trial demand and civil action number 17-CV-5185. The complaint is basically the complaint for federal trademark infringement, federal trademark dilution, federal unfair competition, violation of Illinois' Deceptive Trade Practices Act, and common law trademark infringement. Pretty much speaks to it. I just want to get to this one area, about two areas I want to get to here. And you can see the Wrigley brands throughout the years. And then their Juicy Fruit brands throughout the years. And they have all their patents. These are all their numbers on their patents. Or trademarks, I should say. Patents and trademarks. And the company, Chi-Town, also puts out Skittles, Kahlua, Hawaiian Punch, Mountain Dew, Red Bull, and Nutella, or Nutella, or whatever, which also infringes on, see, this is off of Chi-Town Vapor's website. They're also infringing on these particular brands as well. And you can see their list in their, see, Hawaiian Punch, Mountain Dew, Red Bull. This is all on Chi-Town's website. Okay, so in July 2014, Wrigley's counsel wrote to defendants detailing Wrigley's rights in its various marks and demanding that defendants stop selling products bearing those marks, which at the time were Juicy Fruit, Skittles, and Double Mint. Defendants did not respond to Wrigley's counsel's letter, but removed the images of the infringing Juicy Fruit, Skittles, and Double Mint products from their website. However, by November 2015, defendants resumed marketing and selling e-liquid using the name Double Mint and Double Mint, and copying the look and feel of Wrigley's Double Mint trade dress as shown below. See, and they put that's on their website. See, and not only is the name there, but also the coloring, which resembles the Double Mint bubblegum, which I had chewed in my life. So you can see it's the colorization of it, not only just the name of it, but also the colorization of it, which is going to really get them in trouble. And then even the Juicy Fruit, see, they got the coloring, even though they call it Juicy, Joosy, it's the coloring of it that is going to nail them to a cross, so to speak. And then they go through the claims. I'm not going to get through all that. And then this is their relief Wrigley is asking for. The main thing I want to get to is it's one of the reliefs, or require defendants to immediately recall from all distribution channels all products, packaging, advertising, and promotional materials bearing or infringing on the Wrigley trademarks. Require defendants to immediately deliver to Wrigley for destruction all products, packaging, advertising, and promotional materials bearing or infringing on the Wrigley trademarks. Require defendants to immediately cease sales of the products described above on their website. Order defendants to account to Wrigley all profits wrongfully derived by their unlawful conduct, and to pay to Wrigley all monetary, actual, and/or statutory damages sustained, all profits, gains, and advantages, exemplary damages, prejudgment interest on all damages, and Wrigley's costs and disbursements in this action, including its reasonable attorney's fees. And they are demanding a trial by jury, and it's coming out of Loeb & Loeb law firm out of Chicago. And the attorney that wrote this particular complaint was Douglas N. Masters, attorneys for plaintiff W.M. Wrigley Jr. Company. The thing is, they've been in trouble with the FDA. Now, at one time back in 2014, they had trouble with Wrigley, and then they decided to remove it. And then 2015, they started to do it again. Now they landed themselves in a court of law. This particular vapor website needs to be removed from the face of the earth. And there's not just them. There are many out there that have trademark patent infringements that need to be excuse me, I'm putting new batteries in, that need to have cease and desist letters given to them. And if they do not comply with the cease and desist letter of stop selling these particular products with these trademark infringements, then they need to be taken to court and pretty much put out of business. So it's good to see that Wrigley stepped up to the plate. I had done a previous video showing how a company was sued, a vapor company was sued in the past by a big guy. I think it was Kraft. And now you got Wrigley stepping up to the plate. And these vapor companies need to get their act together. This here, right here, this piece right here, Illinois Deceptive Trade Practices Act, meaning, you know, they put it as JOOSY instead of JUICY, but they keep the color of the bubble gum package the same as on that e-liquid. You understand that the color is what's going to nail them as far as deceptive trade practices. Anyway, I wanted to share this with you. I like to keep you guys up to date on these particular subject matters. You know, if I see anything else like this come down the pike, I certainly will be doing a video of it. We need to not only refrain or rein in those that have all these childish labeling on these e-liquid bottles, but we also need to stop doing all this trademark infringement. These are huge companies. Wrigley is a multi-billion-dollar company, and Chi-Town probably makes, what, maybe, be lucky if they make $1 million a year, if that, and they're going to be snuffed out simply by this lawsuit. It's going to cost them everything, I'm sure. I'm absolutely sure of it. They'll probably settle the case out of court, but they're still going to wind up owing Wrigley a bunch of money, which they probably don't have. Anyway, you got to rein in this wild, wild west. If I'm not doing it, companies like Wrigley will, and they have the clout. They have serious clout to take down any vapor company or any e-liquid company or any vendor website / retailer. They'll do it. Believe me, these guys don't need any of my help. They'll take care of all this, wrap it up in about less than a year. They might go up on appeal or whatever, or settle out of court. But Chi-Town Vapors will get their act together, whether they like it or not. And on that point, you guys have a good one. Bye.